Thank you very much to have the opportunity to briefly introduce to all of you the European point of view of design patents. And as you probably are aware of, we can have design patents and utility patents as alternatives, as well as both to be protecting one device. So in the past we have heard a lot about the alternative feature of the design protection, but I would like to stress that in many cases it is very advantageous to cover a product with a utility patent and a design patent, and hopefully my presentation will explain why. So first of all, I would like to introduce to you subject matter of the design patents, then shortly introduce the procedure for applying it, maybe if there's time to say something about enforcement. So when we talk about design patents in Europe, it is about the appearance either of a whole product as a bicycle or part of a product like the front light of a car or even an ornamentation. And I think this already shows you the broad spectrum of the possibilities you have. So it's not only the hardware which can have a certain design, but it can be the display of your computer, of your iPhone, or within the car. So there are many options where you can think about the aesthetic appearance of whatever you want to get protected. Before going deeper into what a design patent is, I would like to take a short step back and let you know that within Europe we have two systems in parallel for design protection. On the one hand, we have the registered designs, the community designs, for example. On the other hand, we do have the unregistered community design patents, and that might be of high interest for everybody within this room, as in fact, as soon as you bring into the market a product, first in the European unit, you will have, without any registration, a 3-year period of protection automatically. And this is a great issue, as some of the products you might be interested in do not have a very long lifetime. So those 3 years might be of interest for the whole lifetime of your product even. Design patents are also of interest with respect or in comparison to patents in Europe, as there is a grace period of 12 months. We do not have such a grace period in Germany for patents, for example, for utility patents. We already heard that in order to obtain a design patent, the appearance has to be new compared to the known shape font. It has to have an individual character, and this is actually defined by the overall impression which is obtained from the product as such. The threshold for the individual character is relatively low. So even the combination of known appearances create or can create a new design. When I started this presentation, I mentioned that there is a coexistence between utility patents and design patents. And it has been discussed largely in the past, how is it possible to have such a dual protection for technical features? The result is, or maybe let's put it that way, it has become more and more common to see design effects on technical features. So even a motor can have some very appealing appearances, and even in art, when you have a look at contemporary art, it's going to, in many cases, you see technical aspects. But of course, there are some exclusions. Not all technical features can be protected by a design patent in parallel to a utility patent. So if, for example, the design is 100% dictated by its technical function, you cannot have the device protected also by design. If it is a must-fit requirement and there is no alternative, then again, it's a technical feature and it can only be protected by a utility patent and not by a design patent. However, if there are alternative existing, even a technically driven feature can be protected by design. And I think this is very important to know for all the little aspects of any device, that it can also be protected by a design patent in parallel to a utility patent. With respect to spare parts, we do have some discussions going on in Europe for a couple of years. Since 2002, we do have the community design patent within Europe, and since then we are discussing, and also prior to the law having come into force, the problems of spare parts. Can we have a design protection for spare parts? The present situation is that in certain cases there can be a protection in the must-match cases. And however, there is a difference in the different member countries how they treat spare parts. When it comes to how to get a design patent, we have the national rules, as you are well aware of, and of course we have the international Hague registration. The national routes are possible to go forward like national patent applications or European patent application by depositing your request at a national patent office or the Office of Harmonization of the Internal Market, covering the 28 member states of the European Union. For the international registration, you have the possibility to cover presently 64 territories, and it can be one application for up to 100 designs, which gives you a huge possibility and a great range of protection. The Hague registration can be filed at the office in Alicante of harmonization, which I already mentioned, but now since almost a year also by or at the USPTO, but I think we will hear a little bit later about these changes. However, like for an international patent application, also with respect to the international Hague registration, the examination of the requirements is done according to local and regional law and practice. So still we have a difference, of course, within the different regions of the international registration. Very often the question is posed, which is the better option, go nationally or go for the Hague registration? Well, Hague is of course making life easy, as it is a simple single registration for 64 countries. However, it might be a complex thing, and of course it costs more than national applications. And again, there is the risk for new users that they might not know the procedure. However, it is the choice when you have multiple applications. In this case, or in case you want to have a number of countries, it is very cost saving. When it comes to the scope of protection of a design patent, it is pretty obvious that the scope is narrower in case there are more designs around for the same devices. And what we do in Germany, at least, we always start from the informed user and have established a kind of test in order to distinguish whether there is a patent infringement or not. And I just read to you one of the findings of the Appeal Court of Düsseldorf. In the eye of an informed user, being attentive and aware of several designs in that field of the market, two designs give the same overall impression. In this case, there is a design infringement. When it comes to enforcement, it is much easier to enforce a design patent than a utility patent, because judges tend to better understand aesthetic features compared to technical features. For example, on trade shows, it is very often highly useful to have a design patent which can be immediately enforced by an interim injunction, as everybody clearly can compare one design with another design, whereas with respect to the complicated language of a claim of a utility patent, that might cause problems. However, when it comes to the calculation of damages, we have the same three alternatives as we do have for patents. It's the calculation of the actual damages, the license analogy, and the recovery of the infringer's profits. We do have invalidity procedures, of course, for design patents, where the prerequisites of the designs are checked, and I do not want to go into further details on that, but rather, as the time is running forward, shortly introduce to you utility models in Germany. For that purpose, I would appreciate the next presentation. Anyhow, I've been asked to shortly introduce to you design utility models in Germany, and I've been asked to put on a single slide some major aspects of utility models. Well, that is not so easy to do, but I try to do that. We already have seen in the presentation, which was the one before, that it is only possible to obtain utility models for devices. No methods and no usages. Anyhow, there are many devices which can be protected, and the maximal lifetime is only 10 years for utility models compared to 20 for patents. And of course, we already heard that it is a purely registration procedure without examination. This has, on the one hand, the advantage that it is really fast. You can have a registration within a week of a utility model in Germany. On the other hand, it has the drawback that there is a high risk whether whatever you wanted to have protected is actually protected, because it has not been examined by a patent office. So, as very often in life, there are two sides on the same feature. With utility models, we have a grace period of 6 months, which is of great help in many cases in Germany. So, for example, in case you have been on a trade show and you have seen that a certain product has reached a great acceptance, and you go back to your company and there would not be the possibility to go for patent protection in Germany because you have shown the device on the trade show. However, with the utility model, this is still possible. When it comes to prior art, we also have a different definition of prior art for utility patents and utility models. For utility models, every written disclosure is of relevance, and prior usages only within Germany. So if there has been a prior usage in India, we don't really care in Germany when it comes to utility models. And then there is something which really makes the utility models so important in Germany. The next point I have on my slides is that you can derive a utility model from any pending patent application which has an effect in Germany. It could be a German patent application, a European patent application, an international patent application. You can derive the utility model within 2 months after the end of the examination or opposition procedure, which means in case there is a very long examination procedure pending at the European Patent Office and you are aware of a patent infringer, you can derive a utility model and immediately enforce the utility model. This is very often done in Germany, in particular after having received a positive office action, for example, from the European Patent Office, so that you are on the safe side with respect to the legal validity. But still the Patent Office needs a couple of months for publishing the patent. In that time period, you can derive the utility model and immediately enforce the same. And the nice thing about the utility model is that you have the same claims as based on a patent. So you can collect the same damages, you can ask for stopping manufacturing, and so on, exactly in the same way as you can do it with a utility patent. And there's a last difference between a utility patent and a utility model within Germany, which is worthwhile mentioning, is that the legal validity of a utility patent can be discussed in infringement procedures at district courts, whereas with respect to utility patents, you might know in Germany we have a bifurcated system with legal validity only being checked by our federal patent court with the technical judges, whereas patent infringement is decided by the district court, the appeal court, which means the normal courts which do not have technical judges. Well, I think time is up, and I'm happy to answer questions later on.